World magazine. He is a co-founder of the Global Academy for Advocacy in Dispute Resolution. He co-created the ILS-PACT Intercessionis, Mediation, Competition, and Director of Advocate Maximus, International Arb-Med Competition, and he has been judged as the finalist in various national and international ADR competitions and is now an active coach to competing terms. Sir, a very warm welcome, and I believe that with your this session, our students, sorry, we are all at home, and obviously I am with my pets also. I'm very sorry for this. So I think your session would be very beneficial for our students, the audience who would be watching us live on different social media platforms of KU, UWSL, and a very warm welcome, sir. I welcome you all. I would request, sir, to please take over.
Thank you so much, Dr. It's good to be back once again in UWSL. I think I had come, we'd done a boot camp, a 2-day boot camp for about 100 odd participants, almost 3 years ago now. And I think hopefully through Nilang we'll be back again. So just before I start, I would like Pragya, Nishtha, Ritu, Feni to just have your videos on, because I really like to interact while we are, or you can always switch on to Facebook and see the program. But if Nishtha, Pragya, Feni, Ritu, we can have Meet, if we can have your videos on, please. Okay, Nilang, it'll be nice if during the call, if these participants can be either messaged, because so that at least one can have an interaction with them. Even Kaustav, if they can, it'll be nice. Apart from that, we can, I guess, start with certain questions that you had as we were talking, and I'd love to address them today. Nilang, you're on mute.
Sir, am I audible now?
Yeah, now you're audible, yes.
Okay. So my introductory question would be like, India has a very rich inheritance of justice delivery system. So the role of a judiciary as a guardian and guardian of constitution and fundamental rights has been an immense. And the ADR has been brought into our country for reducing the quantum of conflicts that we have. So, sir, as an introductory question, and just to grab on some basics, can you just please elucidate on some mechanisms? What is ADR? What are the types of ADR mechanisms and process?
Okay.
Sure. So I think it's very important to understand the distinction between mechanisms in ADR, right? So everyone knows, when anyone speaks about what is ADR, or if anyone asks what is ADR, we say ADR is basically alternate dispute resolution, and it has, arbitration, mediation, negotiation, and conciliation. However, a lot of us don't know as to what exactly they are. Right? If the distinction, everyone thinks that, okay, mediation and conciliation are the same. If you ask a layman client, they'll say, oh, arbitration, mediation, it's the same. So idea is to understand, so I'll break it down into what is arbitration, mediation, negotiation, and conciliation, so that we get an understanding. But before that, is anyone, any participant on the call right now, have you ever, been a part of a dispute during your internships, maybe saw a case that you remember, or just an argument that you might have had, in your life, or a dispute that you might have personally had? Is there anyone? Pragya, Dhairya, Abhinav, do you have you ever been a part of a dispute before? None? Dhairya, have you been a part of a dispute?
Sir, hello, sir. Am I audible?
Yeah, you're audible.
Sir, basically, I am talking about a personal issue where I was living in a society, and it was the first bungalow where there was a commercial building was being built.
Correct.
So these society members filed in the court to put a stay on it.
Correct.
So I have known about this issue pretty well. At the end, the corporate building was allowed but it was a pretty good case which almost continued for 2 to 3 years.
Okay, so that's a very good example. Let's take that example, right? So there is the issue. You said that there is a society where there was a corporate building that was coming up, and the society members did not want that corporate building to come up for various reasons. Nilang, can you please mute Vaishnavi? Yeah. So
yes, sir. Understood.
I think that's that. So in such a situation, now let me break this same example of corporate building coming up in the society members not wanting the same and going to court. So one way is they went in for litigation, as you rightly said, that they ended up going to court, right? Now, if in the same situation, the builder, okay, let me take up arbitration. In court, you have a judge, correct? You have lawyers who argue the matter. There are documents that are given. There is evidence that is given. And then a judgment or an order or a decree is passed, correct? Now, if you move on to arbitration I would say is like private litigation. And why I would say that is, instead of being in court, correct, you are in a more private setting. It can be, people hire rooms in a club, people can hire space in a hotel, it can be in someone's office, it can be in someone's home. So there is a setup that, normally people have, okay? Now in that setup, so instead of court, you are in this establishment, which is a hotel or someone's office, or, a room that someone has, number one. Instead of a judge, there is an arbitrator who's sitting. Okay? So in court, you had a judge. Here you have an arbitrator who's sitting. Judge pronounces, the judgment, passes the decree, passes an order. Arbitrator will pass an award, as in the ultimate, the ending of an, the arbitration proceedings is, with an award, right? So instead of a judgment, he passes an award. In both the cases, there is a lawyer who's there, or there are lawyers who are there from both the sides who argue the matter, right? So in essence, yes, the only major difference I would say is that procedurally it is more relaxed. You don't need to follow the CPC like you do in court, right? If Nilang and I have an agreement today saying that, okay, I have to supply oils to Nilang, right? And Nilang says that if out of this contract there is ever a disagreement or a dispute that arises, then we will go in for arbitration. We will appoint one arbitrator mutually. Within the first 2 weeks, we will submit all our documents. And within the next 2 weeks, we have to at least complete our first set of oral arguments. Just give an example that, okay, this is what we have in the agreement, and we say that the Indian Arbitration Act is what we're going to be following. Now, when the dispute arises, we will have to follow what is written as per our agreement, where both of us will mutually appoint one arbitrator. Within the first week, we will need to give the documentation because that's what we've agreed. So Nilang and I can actually set out the procedure that we should follow in the contract, and that is what would ideally need to be followed. Okay? Now, so in essence, you're saying that we're not following the CPC, but we are following what we've written down, or what is given in the Arbitration Act, or whatever we've written in our contract. These are the procedures or the institution procedures that we're going to be following. So it's private litigation. There is, instead of a judge, there's an arbitrator. Instead of a judgment, there's an award. Lawyers are arguing the matter, and a judgment is pronounced, where the arbitrator decides what the outcome should be. Okay? That's arbitration for you. No difference. So people think, oh, arbitration is something different. No, procedurally, it's, if to explain it in layman terms, it's the setup is almost the same, I would say. Of course, when we say that, okay, I'm going to apply the SIAC rules, or I'm going to apply the DIAC rules, then of course there's a difference, because the rules that are being followed are from there. But in essence, when you're talking about the role of a lawyer or a role of a adjudicator, it's the same. Okay.
Okay.
Now, in the same situation, which we spoke about, there being the society members and the builder. Okay. If the society members and the builder that there is talking about come and sit across a table, and they try to resolve the dispute amongst themselves, right? There's no third person, there's no judge, there's no arbitrator, there's no third person. It's just the society members and the builder on the other side. If they try to resolve their dispute, if there are only two parties over there, right? Then it is a negotiation. So if Dhairya has an argument today with his mom, and he doesn't involve, and it's a discussion that is taking place between Dhairya and his mom, it's negotiation. If I am talking to a fruit seller, it's only the fruit seller and me who are talking, it's a negotiation. Now, if the society members, like you said in your example, if the society members decide to hire Nisshant as a third person to help resolve the dispute, right? Then my role is that of a mediator. It becomes a mediation. So negotiation shifts into mediation. Can you just Manthan, please? Yeah.
Manthan Sharma.
Yeah, he's muted. So
can you just slight distance? Yeah.
So negotiation is only when the two parties are discussing, negotiating, talking. There's a dialogue between the two parties in conflict. The moment they cannot resolve the dispute and they say, okay, we want to have a third party who's a neutral party try to help resolve our dispute, it becomes a mediation. Okay? In a mediation, my role as a mediator is not to pronounce a judgment or pass an award. I cannot do that. If today the society members and the builder, despite me being there, they do not come to a resolution, I cannot force them. So be it. They're not coming to a resolution. I cannot force any solution upon them. I can't. Okay? So it is up to the parties to decide. Yes, where I come in is I can play the role of a facilitator, where I'm trying to help, where I'm trying to understand the concerns of both the parties and trying to put it before each other or on the table. Basically, I'm trying to build trust and have a communication bridge instead of a communication gap. And in conciliation, it's the same thing. There are the builders, there are the society members, and there's Nisshant as a third neutral. But here, Nisshant can actually suggest solutions to the parties. I can tell the society members, okay, after having heard all of you, I think that if you take up, the builder is willing to offer you a compensation of, say, for example, 5 CR. Maybe you can take that and use it towards the maintenance of the society, for which none of you will have to ever pay, at least for the next 5 years or 6 years, because it will go out of this. So here I, as a third neutral, I'm actually giving suggestions. So strictly speaking, a mediator does not suggest, right? He will maybe put his idea in the form of a question. If I'm a mediator in this dispute, I will ask, okay, Dhairya, you being the society, what do you think about the offer of 5 crore rupees that the corporate builder is giving you? Do you think it can be used somewhere? Can it help you? Right? But if I'm the conciliator, I can say that, okay, Dhairya, he's willing to offer 5 crore rupees. How about putting this into your maintenance? The society will not have to pay. So here I have suggested. That's the only difference. So arbitration is like I would say private litigation. Instead of the judge, you have the arbitrator. Instead of judgment, you have an award. Both the lawyers are arguing. Negotiation only when the two parties are in conflict or are communicating. When they cannot come to resolution, they hire a third party who's a neutral party who can facilitate the conversation, not pass a judgment. And in conciliation, the same person can give suggestions. That becomes conciliation. That's it. That's the difference between, you know, the processes of, or the mechanisms of ADR.
Okay. So it was like a nicely explained one. Like arbitration is more of a binding one than compared to negotiation and
Yes,
conciliation.
arbitration, I would say, is adjudicatory in nature, because
Okay.
there is an arbitrator who's giving out an award, so he's adjudicating the dispute. Whereas mediation, negotiation, and conciliation are consensual dispute resolution mechanisms. Why? Because it is up to the parties to come up to a solution, and no one can force a solution on them. Of course, once they've come to a solution, they have an agreement that becomes binding.
Okay.
Right? But in an arbitration in court, what the judge says, what the arbitrator says is the award. Right? You will have to, parties will need to, they can go and challenge it,
binding on them.
but they will have to follow whatever is written as per the agreement. But in mediation, negotiation, conciliation, they decide the solution, they decide the outcome, they write it down, and then they kind of sign it. So it is basically me deciding along with the other party what the outcome should be.
Okay, right, sir. So moving on with my another question, sir. Sir, what I have observed is that conflicts always springs from small disagreements. So now, what are the, like, an effective mediator should have the qualities of understanding what are the root cause problem of conflicts. And in ADR, we also hear that there are some models of understanding the conflicts also. And like, what is your suggestion, and like, what are your views, what a effective mediator should possess, what are the qualities? And we, as the audience is majorly law students and future lawyers, how does the law students sharpen their skills to be an effective mediator or to be an effective ADR professional, if I must say?
So Nilang, honestly speaking, being a mediator, there are certain soft skills that you need to have. It's my personal belief that let me take an example. A mediator really needs to be a good listener. If Nilang is not a good listener, he will not be able to listen to what the parties are saying. He will not be able to understand what their underlying problems are. Nilang will be able to understand, okay, X party is wanting to give 5 lakh rupees as damages, and Y party wants 7 lakh rupees. But why are they stuck on those numbers? Why are those numbers important to them? Right? So you need to be a mediator, really needs to be a good listener. If you and I believe that's something that comes with a lot of practice, because we as Indians love suggesting, and we try to jump in to giving solutions, right? We have this habit, mujhe pata hai, mere sath ye hua hua hai, I know it, and I'm going to give a solution. We end up giving solutions after listening to someone for 10 minutes. But the idea is to listen, gather as much information as you can, and that again will come with listening. When I mean by gathering information, how can you gather information is by asking relevant questions, open-ended questions. So that's another quality that a mediator needs to have. He needs to be able to ask open-ended questions, or the type of question that he needs to have. He needs to have a knack for that. Because if I ask Nilang, do you like having pizza? Nilang will be like, okay, no. Now I wanted to understand what Nilang enjoys eating, correct? But I asked Nilang, do you like eating pizza? Nilang will say no. Did that help me with an answer? No, it just showed me that, okay, Nilang doesn't like pizza. But alternatively, if I ask an open-ended question where I ask Nilang, what do you like eating, Nilang? You know what, Nisshant, I like eating Mexican. And then in Chinese, I like eating this. In Italian, I don't like this, but in Indian, I like this. So I've gathered so much information just by one question that I now, not only do I know whether they like pizza or not, but I know what you like in Italian and in Chinese and in Indian and in Mexican, all of it. Correct? So asking open-ended questions. Okay. Then it's very important for a mediator to be able to empathize. By empathize, I mean he needs to put himself into the shoes of the other party and look at the dispute from his angle. If you cannot feel or understand what the parties are feeling, you might not be able to help them out. Because you might think that, oh, X solution is good, but party is not willing to accept it. Why is he not willing to accept it? So you need to put yourself in their shoes. And this is a very common example. In my final year of law school, I remember we wanted to go to Goa. And, everyone likes in the final year of law school that there needs to be one Goa trip. Okay? So there was this friend of mine, there were about 12 odd people. And there was this friend of mine whose mother said, okay, no, you're not going to Goa. There's always that one parent who says, no, So she, so he kept fighting, she kept fighting as to, I want to go. It's my last year. I need to go with my friends. Why are you stopping? So she started fighting, right? But the idea is to understand. So I can continue fighting like that. That person will have continued fighting. But idea is to understand why the mother is not allowing her to go. Okay? And then trying to resolve that. So that is what a mediator needs to do. It's not about me. It's a mediator's job doesn't end at knowing what the parties are wanting. A party is saying, okay, my mother says I cannot allow her to go to Goa, and the daughter says I want to go to Goa. Correct? That's okay, but that's not the end of my job as a mediator. I need to understand. I need to put myself in their shoes and figure out why does the mother not want her to go? Why is the daughter wanting to go?
Of like,
Okay, so I think that I'll break that into two. One is how should, what should future lawyers focus on in their law school time, right? With regards to pursuing an ADR career, that's one part. And second, I'll take up the part of being an ADR entrepreneur, or even for that matter, legal entrepreneur, right? So I'll take the first one. So whether ADR, whether IPR, whether, arbitration, anything, it can be, a student might want to pick up any subject and want to specialize in it. Okay? What is really important is, number one, that they really need to read. If I like IPR, I really need to read. Read as much as you can. There are blogs, there are articles, there are books. That's something you have to do. There is no shortcut to reading if you're wanting to specialize in a particular subject. That's number one. Number two, I'll say there are so many opportunities that one gets to write. It can be a blog, it can be in a journal, it can be an article, maybe start your own blog. So second one I would say is writing. So reading, writing, and the third I would say is the extracurriculars, which is go for competitions. Because you might or might not remember what research you did for a lawyer at your internship, but you will always remember for the rest of your life what you did during a moot. The research work that you did for the moot, you will never forget that, or the experience that you had, or the exposure that you had. So mooting, competitions, training workshops to build your CV. And why I say all these three is because when I, as a recruiter, am recruiting someone, there might be a Abhinav Jha in front of me, and there might be a Dhairya Patel in front of me. Okay? Now, Abhinav has, say, an 80%. Okay? And this is a job for a position of an arbitration associate. Okay? So Abhinav has applied, Dhairya has applied. Abhinav says, or Abhinav CV reads 85%, has done internship in some IPR, some companies, workshop in labor law, written in 5-6 different journals about 5-6 different articles, right? Different subject areas. Now, and I'm restricting myself only to a niche. So if I am looking for a um, arbitration associate, right? And on the other hand, I have Dhairya, who's not an 80%, but who might have a 75% or a 74%. However, he's done workshops in the field of arbitration. Say of course, in the first 3 years, you are just figuring out what you want. But say I see Dhairya saying that, okay, starting the 4th year, I see on his CV that he's written blogs in the field of ADR. He's written articles. He's done competitions in ADR. He's done moots in ADR. He's done maybe internships in the field of ADR. That will show me that there is interested specifically in arbitration, and there's a higher chance that I might go towards there because his CV is showing me that he's interested in ADR. And that's what people always ask, that how do I build a strong CV if I want to do an LLM? Well, there are thousands of applications that come over there. Your CV needs to show a narrative to them. From your CV, they need to be able to see that Dhairya or Abhinav are interested in arbitration, and it will make sense to give them the arbitration course. If Abhinav has his entire CV based on IPR and he's applying for an arbitration program versus Dhairya, who has his entire CV based on arbitration, applying for an arbitration program, there's a higher chance that Dhairya will pick it up. Why? Because his CV is showing that this is the field that he is interested in. So I sitting over there will, or the person looking into applications will see that, hey, you know what? This person is interested. He's shown the interest. Why not give him the chance? More often than not, that's kind of the mindset that happens because there are thousands of applications over there. Let's face it, no one has the time to go through those. Even when you're applying for internships, no one has the time to go through each and everything. But they need to see that your CV shows a narrative with regards to the field that you're wanting to enter. Yeah, and so that's about how should future lawyers focus on the law school time with regards to pursuing career in ADR, which I said, reading, writing, and extracurriculars, of course. And then by the 4th year, if you understand, or the 5th year, if you know what you're wanting to do, try to build your CV around that so that the recruiter or the interviewer, by the look on your CV, knows that this person is interested in the field that he's applying for. That's it.
Okay. And
the second part of the question, Nilang, was that what if a student wants to become a legal entrepreneur?
Entrepreneur, yeah.
So since I can see Abhinav and Nere right now, or even Nilang, do any of you have plans of becoming a legal entrepreneur, or even do you have an idea of a startup that you have in mind?
Yes, sure. Basically, I have an interest towards entrepreneurship after law, to adopt a particular, not maybe sometimes I feel that it can be of any field, but from by joining legal point of view and business, I have thought of a startup like we can develop a site where there are a combination of lawyers on the whole site, or basically develop an app where there are suppose if a person wants to find a lawyer in a specific field, he can choose the field, and there would be list of lawyers in of that particular field, or specialist of that particular field. So basically it was a small idea, but that I feel that such a site is not yet more popular in today's time. It may in future
startups are all about ideas that were not popular, but there were a bunch of people who thought that it'll work. I mean, you look at Elon Musk.
Exactly.
Who thought he's going to be able to land a rocket back, or a part of it at least, back onto Earth. I mean, even NASA did not do that. But well, if he thought at that point in time, hey, this is something that is not being done otherwise, so let me not do it. Why? Because other people are not doing it, or it might not, or it might fail. Then you would not have had a SpaceX, or you might not have had a Tesla. I mean, you would have said, you know what, there are so many petrol or diesel cars running on fuel. I don't think a battery operated car will work, right? So you would never have seen a Tesla. So idea is startups are based out of ideas that are not currently there. If it's already there, then it's there, right? So I would lay down 4 points there. Yeah, taking your example of saying, okay, you want to build a website, which is like a directory of lawyers who are divided in on the basis of their specialization. Am I correct?
Yes, sir.
So there'll be a website which says, okay, lawyers for labor law. There'll be a list of those lawyers along with the profiles, and you'll say, okay, list of IPR lawyers, and then there'll be a list of lawyers over there along with their background, and so on and so forth. Okay. Now, I would always say the first thing that there are 4 very important things that you need to see to have a strong foundation to your startup. People have lots of ideas, but you need to look into these 4 points. Otherwise, there's a high chance that you will either it will fail, or you might lose interest after a point in time, or it might not pick. So the first thing that I always tell people is, or people who want to become entrepreneurs, is to ask themselves rather, why do they want to have this kind of a startup? Okay. And then I tell them that, okay, you need to write down the answer in your notebook as to why do you want to start this venture. So if I were to ask you, Dhairya, that you're saying that, okay, you want to build a directory of specialists in the field of law, why do you want to do it?
So basically, sir, giving a brief background of myself, I am from a law. Basically, my mom is a lawyer. So
Right.
from childhood, I have been into my mom's office, and I know what things happen at a lawyer's office. But many of times, it has happened that certain client comes to my mom and asking for a reference of a lawyer of another field. In particular, our legal business, lot of clients would go to a lawyer which is being suggested by another lawyer which is close to them. So it is based on trust rather than their qualifications or statistics, something like that. So I think like that, if there may be chance in future where the whole legal field would be like based on the merits and not on the basis of relations or not on the basis of trust, like that. So in future, if a certain person wants to find a lawyer, they could clearly go to the app. Like right now we have Zomato. If you want to find any restaurant, we can clearly go on Zomato and search on it. Basically, in future, if there would be any app like that, a certain person will go onto that app or to that site and find the lawyer which he is looking for. Then there would be list of lawyers with there may be a brief background about them, their performance on certain cases in their field, their experience. It would be very better for a person, maybe a layman or maybe a common person, to find a good lawyer, because half of the times they do not get the perfect man to do the job.
Okay, fair enough. That's a very valid point that you're saying. So,
Yeah.
if I ask Dhairya, why do you want to, why you wanting to enter this venture? If I've understood correctly, you're saying the reason is that you have seen the requirement of specialist practitioners, correct? At the same time, you want the clients to be able to reach out to practitioners of that field basis the merit and not just basis the connect,
Exactly.
so that the clients get a better experience. Why? Because the particular practitioner suggested is or specializes in the area in which the client is searching for a practitioner, correct? So that becomes the why. Okay. It is on the basis of this why that your entire venture will be um, be built. Because if the answer to the why is, say for example, I want to earn 10 lakh rupees out of this venture, then the moment you hit the figure of 10 lakhs, you might not be motivated enough, because you said, okay, this is the reason, and fair enough, I've earned it, and now I don't know whether I want to take it forward or not. You can, 10 lakh rupees tha, ho gaya khatam. Which is why it's important to understand why you're wanting to do it. Now I've understood that, okay, Dheere has an answer to the why, that he wants meritorious people be connected to clients based on the specialization that clients are looking for, rather than on the basis of connect. Chalo. To be able to do that, to be able to connect, what do you need to do? There can be many ways, correct? But you have set a goal, so to say, that okay, I want to do this through a website. Okay. Now, what do you want to have as the end goal of the website? Like, how do you, if I were to say, okay, Dhairya, I will give you all the resources that you need. Like, you name it, and by tomorrow I'll provide it to you. What is where do you see this website, or what is the goal that you have for this website? Like Elon Musk says, you know what, I want to build a colony on Mars. Why does he want to build a colony? Because, you know, he realizes that the resources on Earth are limited and we might need to expand. So that's the why. Now his goal, to address the why, he made a goal that I want people to be reaching Mars. I want to have a colony on Mars. Correct? That's the goal. So what is your goal for the website?
So the main goal for my website would be to reach to the maximum amount of people as possible, so they would get the right man for the job.
No, so your answer is vague. I want you to put a number. It needs to be specific. See, the why was very specific. Why you wanted to do it, you write that down. Goal also needs to be specific. How many people do you want to reach? You don't need to answer that now. Yeah, so you don't need to answer that now. But idea is to say that you need to put that down. Right? Everyone has a goal.
Basically, what can I do is I can see the statistics of the number of cases maybe pending, or the number of average cases in a particular month. Then I can deduce some of the some figure on the basis of that.
So that's how you have to reach that goal. I'm saying, what goal do you have? How many practitioners do you want to have on your website? So in the say, I want my website to be number 1 in the Google search engine.
Yes.
Okay. I want about 500 practitioners. I want to be able to generate revenue out of it. Say I want to generate 10 lakh of rupees per annum from this website. Okay. So these are the 3 things I've put as my goal. That I want this to be number 1 in search engine. I want 500 practitioners, and I want 10 lakh as revenue per annum. Now you know the goal.
Yes.
Okay. So I've put that goal. Now to achieve, now to achieve that goal, what do you need to do? That is what you were just answering, that okay, I will look into the number of cases, I will reach out to practitioners, have their CV, get their background check, whatever. So, and once you know that, okay, this is how I can achieve my goal, you'll say that I'm going to take a fee from every practitioner that gets work from my website. Okay?
Correct.
That becomes, your fee. You need website development. You need all of that.
Yes.
So you know that, okay, these are the resources that I need. And then you need to figure out that, okay, to be able to pull this venture off, what is the team that I need? In terms of people, what are the skills that each member should have to be able to achieve the goal? So why you're wanting to enter into this startup? Write the why, write the answer to the why. The goal, set a goal for yourself. Where do you see the startup, or where do you want to see the startup? To reach that goal, what are the resources that you will need? Whether it can be money, it can be people, it can be, promotions, whatever. And finally, the technical competence that you will need to be able to execute the venture, which will comprise your team. These are the 4 things that you really need to look at, whether you wanting to become an entrepreneur in the field of ADR or otherwise. I mean, I'm going by my personal experience, and it has worked for me. So that's that.
So, Daria, any other thing, like, are you clear on that aspect?
Yes, I'm clear on that point.
Yeah. Sir, to this question has been like I have been like seen many a times. I've seen that question. So finally, how much of it holds importance, or it is important for any law student or a fresh graduate to be associated with a large corporate firm or a big short company or a corporate firm or any big business basically after a person graduates, and especially when he knows he has a plan and he wants to be a legal entrepreneur, as we are saying right now. So what are the quantums and facts of, like, is it today in the industry, is it possible for an entrepreneur to self-sustain, or he needs to in his initial years of his career he needs to work for the big associations or any company per se?
I personally don't believe, and I'm sure a lot of people will agree, that working in a corporate law firm is a mark of success. Not. If I want to be a mediator and I end up joining a corporate law firm where I'm doing IPR related work, I might be getting 2 lakh rupees a month as salary right after right after I graduate, which might be more than what other people right after graduation are getting. It's not going to help me in the field that I want to get into, say mediation, because if I don't get mediation practice while I'm doing an IPR, then it doesn't help me. Yes, if I want to be in a mediator and the IPR firm gives me the scope of being part of mediations, then yes, it makes sense. But saying that, okay, right after law school, you need to join a corporate law firm and that is going to be a mark of success, I disagree with that. What is your aim? What do you ultimately want to become is something you need to see. And basis that you need to look for the opportunities. Okay? It's like saying, if I'm feeling thirsty, right, I end up having Coke. Coke is going to make me feel even more thirsty. I need to have water at that point in time. Correct? So that's the whole thing. You need to know what you're wanting to do. And based on that, if I want to become a corporate lawyer, yes, of course, joining a corporate law firm will make sense because that's what I want to do. If my aim is to become a partner at a law firm, then yes, I want to join the law firm. If I end up at a mediation center, whereas I want to become a partner at a corporate law firm, it's not going to help me. So you need to decide, what do you want to do? On the basis of that, you need to select a job that will help you achieve that target, not help you generate revenue. Unless, of course, there are I've had friends in law school who've had to support their family because they might not have been financially strong, because of which they picked up corporate jobs, correct? And they felt that, okay, their need of the hour was to support the family, and that's why they picked up a job at a corporate law firm. Fair enough. They might have wanted to become something else, but at that point in time, they felt that that's the need. So they went for it. So you need to see, what do I enjoy? Is that particular job, if I want to become an arbitration practitioner and there is a camp that is offering me a job in the IPR team versus there is another independent lawyer whose practice is run on arbitration, I might want to choose arbitration because that will help me create a foundation in arbitration on which I can further build upon to be able to do a better job in the long run. So wherever you get more exposure, not a corporate law firm being a touchstone of success. I would not agree with that.
So it's like a very informal question now, following the same topic. How is the culture revolving around the profession right now? in ADR, if you say, like any specific views on that?
Yeah, interesting. So people always, students or people, they might be advocates, they might be clients or the users, so to say, would always ask me, what is the scope in mediation? There's no scope, there's no future. And now when you have a pandemic like situation, everyone's turned to ADR.
Yeah, it comes out to be a fascinating endeavor of law.
There are lawyers who are now saying that clients are not wanting to go in for litigation because they don't know when they're going to get a hearing, so they're trying to mediate the dispute. So जब कोई चीज काम नहीं आता, तब everyone turns to mediation. So it happened at the same time. Ayodhya dispute, 20 years in court. At the end, they did turn to mediation. If mediation or conciliation, negotiation wasn't something that had scope, they would not turn to it. So I feel that clients need to become a lot more aware, because only if the client tells the lawyer that I want to go in for mediation or negotiation or conciliation, will the advocate drive them towards that. And that's something that I feel is important. So now that this pandemic is there, clients are realizing what they stand to lose if they go into court, which is why now they are moving towards mediation. And I'm glad, because those who have a good experience in future will pick that up as a mechanism to resolve their dispute. So it will take time. Arbitration is already, arbitration is there, of course. It's more prevalent, but even mediation, negotiation, mediation and conciliation, it will take time, but it will come slowly as more and more clients make use of that mechanism and they have an experience. There is a higher chance of them, suggesting it to other people. It's like saying, if you find a product that is very, very good, you'll recommend it to other people. Right? So here, if they see that a mediation is something beneficial, they'll end up, recommending the same. So I guess this pandemic has kind of shifted clients towards resolving disputes outside of court, and I hope, the culture keeps growing. But still a long way to go.
Yeah. Okay. So one last question for benefit, which will benefit. What are the sources that you use for updating yourself in the field of ADR? Like any specific blogs, any specific readings that you should do, especially when you're pursuing ADR as a career ahead?
So I think blogs are very important, because of course you'll have articles and journals that give you a lot of theoretical content, but I think blogs end up giving you views of different people, because blog is normally more 1,200 words about what I feel.
Yeah.
Right? It might not be, might or might not be theory based, but it's my viewpoint. So I really like reading blogs. There's mediate.com, there is Pure Mediation. So blogs like these should be read on a daily basis, because it doesn't take too much time to read them. They're normally blogs between 900 to 1,200 words by, practitioners who are, very, very well known in the field. So blogs is something that one must read, because like I said, it doesn't take too much time. A lot of people say, oh, there's so much work and I have a lot of work to do, whether it might be, during the professional career, it might be at law school. Fair enough. If you cannot read 30-page articles, how about starting with blogs? Once you get into the habit, then you can end up reading, of course, the journal publications that happen, and judgments. I feel in the field of ADR, it is very, very important to read judgments, because every day ADR is slightly on the more dynamic side, and there is some judgment or the other that's being passed, but it's important to read judgments. So that's something one must read. Log into Manupatra, ICC, whatever. But it's really, really important to read judgments, I'll keep you updated.
Okay. Okay, sir. So, concluding time, sir. So, on behalf of United World School of Law, it was truly a pleasure having you, and you gave all the answers with a lot of clarity, and we got clarity on many important topics. If we talk about ADR, so thank you so much, sir. It was a pleasure having you, and thank you to all the participants also for such an interactive session.
Thank you.
Thank you.
Thank you so much, Nilang, and I hope soon we can be at your university, whether online or offline. And
Yeah.
the workshop where we can train students for competitions.
I would also like to tell participants that Sir is a partner at a company called PACT, and one of their services is like training for competing teams. So we are having talks with our dean, and I hope that it will soon turn out to be an interactive course of session for
Yes,
next time.
so PACT is a training and education firm.
Yeah.
And one of the things that we do is something called a boot camp. It's like a 2-day workshop, which trains you to be a mediator, or at least I'd say rather orient you on how to be a mediator. So you'll have the theory, you'll have role plays, you're given feedback on that, which also helps you then go for competitions and represent the university. So we teach you things like how to make an opening statement, how to handle a caucus, how should a mediator ask questions, and of course the laws. So the skills aspect of it, which can help you in your in competition the students attend later, or even in the practice in the field of when they go into the practice arena.
Okay, sir.
Thank you,
so
thank you.
Thank you. All the best to you. Okay. Thank you, all the participants. So you may end the meeting now.